Kristen, Kaley, thank you so much for joining us on the show today and truly for your courage in taking on this issue head on. For those unfamiliar with the case, can you walk us through who both of you are and what today means in terms of your continued fight for free speech and against censorship in the world of counseling? Why don't we start with you, Kaley?
Well, I'm Kaley Chiles. I'm a counselor in the state of Colorado, and I am now the named party in a case that I'm bringing to the Supreme Court.
Amazing.
I'm Kristen Waggoner. I'm the CEO and also Chief Legal Counsel at ADF, and this is one of our 4 cases that are at the court this term. The case focuses on free speech, and in particular in the context of radical gender ideology and what can happen in a private counseling session and what discussions can occur.
So for those who are really unfamiliar with this law, I didn't know much about it until I started doing research about your case, and I grew up in Colorado. But just to see how much things have changed so radically in the last few years, I think is really shocking to people. What is this law that you are challenging, and what specifically is it telling counselors that you can and can't say in these counseling sessions?
Well, the law was put in place in 2019 by the Colorado legislature, and it essentially says that a licensed counselor is not able to have voluntary conversations that a client is initiating and is in line with their personal goals if those conversations touch on the client's desire to change their identity by way of behavior, feelings, affections, expressions. Any of those conversations would cause Kaley possibly even to lose her license, but certainly it would start out with a $5,000 fine and then would continue to possible revocation of her license in the end. So that is truly infringing and peering into a private counseling session and a private conversation. And there's no other law like that in the counseling profession. I think Kaley's best equipped to talk about how that impacts that counseling relationship.
Yeah. So for me and my clients, that just means that on one topic only, we cannot operate as we operate in all other topics.
And what topic is that?
Well, the topic of sex and sexuality, right? And otherwise, we can build a genuine therapeutic relationship. My clients come to me and tell me what brings them to counseling, what problems they see, what goals they have. And I offer them a conversation about how I can be helpful. And so we kind of decide together how to move forward and if we think we might be a good team. And unfortunately, in this case, the whole premise changes, the whole conversation changes because we have our goals dictated to us by the state instead of being able to have a genuine, full conversation.
So help me understand this. If I'm a 16-year-old in the state of Colorado and my school has been pushing gender theory over and over and over again in all of my classes, I all of a sudden decide I think I want to be non-binary or I think I might be trans. If I took on a counseling session with you, Kaley, and I said I thought I was going in that direction, you are only allowed to counsel me further into gender transition, not at all ask questions or push back against that in any way?
That's true. Yes. If the conversation is perceived a certain way, then I, as a counselor, am in danger of a $5,000 fine and revocation of my license if I am in some way violating the statute.
Wow. And talk to me, Kristen, about what this has looked like with the legal challenge associated with it. Obviously, you hear about a law like this and it's unconstitutional is the first thought that pops into your mind. But this was passed in 2019 in the state legislature, and here we are in 2025. Why has this taken so long?
Well, cases often take a long time. I mean, it's not unusual for us to litigate a particular issue or a case, for 10 years and have to, again, go through multiple cases in different jurisdictions in order for the court to grant it. I think, people need to understand that for the Supreme Court to hear a case, they have to understand and conclude that it's an issue of national importance and that it affects more than one state, usually. And so sometimes it's just a matter of time where these problems get bigger and bigger, and finally the court says, okay, it's time for whatever reason for us to step in and bring clarity. And that moment, I believe, has come for these laws. There are other states that have passed these laws, all within this brief period, that I would classify as sort of a transgender craze. As you've talked about, we've seen a sociological phenomenon, particularly among girls. And in that time period, Colorado in particular has pushed forward a radical view of gender ideology that actually contradicts a mounting 2018 evidence that suggests not having these conversations is truly harmful to kids. And it's important to recognize that this is viewpoint discrimination. It's also content discrimination. Those are legally loaded terms, but I think what it is clear is that the free speech clause protects Americans from being able to have private conversations. And if the state's going to come in and censor those conversations, the jurisprudence says they must have a really compelling reason to do so and not have a lesser restrictive means to be able to accomplish the harm that they say they're remedying.
Yeah.
Here, there is no harm, though. In fact, their evidence demonstrates that. They can't even prove that there's harm from simply listening and talking to kids.
That's the part that I think is so shocking to me, is just the concept of an open conversation about this. People like Chloe Cole come to mind, and this growing detransitioner movement to be honest about the fact that these young children and teenagers are being pushed only in one direction before they ever even have an honest conversation about what gender transition would really look like for them. All of a sudden, they find themselves laying on the table for a scheduled top surgery or taking life-altering drugs and hormone therapy for the rest of their teenage years, and then they wake up at 20 or 21 years old and say, oh my gosh, why did no one even ask me a question if I was sure I wanted to do this? It seems to me that whether you would be in favor of transitioning minors or you would be vehemently against it, just the conversational piece is so important from a counseling perspective. Why is the state trying to remove your ability to have that conversation in the first place?
Well, it's hard to say what the state's mind is about this issue, but absolutely, I think we can all agree that regardless of our opinion about this topic, we all are on the same page that we should be able to speak freely, especially on issues of our mental health and concerns that we have, because not talking about it is really not an answer. To be able to talk about it fully is what counseling is about.
If you could share your message as a counselor with the people who passed this law about why it's so wrong and why it needs to be challenged, what would you say?
I would probably reference the many people who don't have access to care right now, that there are adolescents, there are their families who are suffering right now. I am allowed to help people who are seeking something like a gender transition, and I am simply not allowed to help somebody of a different mind. And all of those people don't have access to care right now.
Why do you think Colorado in particular has become almost this petri dish experiment for some of these crazy ideas? I think about all of the cases ADF has taken on representing Colorado. There's summer camp counselors dealing with issues like this, cake bakers dealing with issues like this. It all seems to be centered around this growing LGBTQ conversation and where our country is splitting in two different directions here. But why Colorado? I would have expected this, even as someone who grew up there, more from California, New York, or Illinois, perhaps.
Well, I would say that you have a pretty radical legislature there,
these days,
as well as, the governor and the attorney general. We have a number of cases. Two of the cases I've argued at the Supreme Court were both against Colorado in these areas. But even more so, as you referenced, like we had a case called Camp Idrahaji, which involved whether boys could be in girls' dorm rooms or, camp rooms. But we have a case right now involving a secret transition in a hotel room. All of these issues are coming up in Colorado, as well as in a few other states. I think that what we need to remember, though, is in this particular area, 90%, the science tells us that upwards of 90% of kids that are struggling with gender confusion, that are struggling with being at peace with their bodies, if they are allowed to naturally proceed through adolescence and having these conversations, they will live at peace with their bodies. They will be comfortable with their bodies. And yet the science also says that in 97% of the cases where you start to socially transition a child, that you are putting them on a one-way path towards identifying as the opposite sex and having irreversible harm occur due to drugs or surgeries. So again, I just think that going into the counseling room and telling Kaley she has to read from a set of talking points that only ratchet the conversation one way, it's deeply disturbing and at a minimum would require a much higher level of scrutiny under the First Amendment than what Colorado's willing to provide.
It's really telling to me that we're having this conversation in real time as our legal system is trying to figure out how we navigate the transition of minors. Because of the Scrimeti case, which I know ADF had a very heavy hand in, we're already seeing a major policy change in in allowing for the surgical transition of minors to begin with. But how does this look on the counseling side? Before we ever get to a hormone being prescribed to a teenager, before we ever get to a surgery being scheduled, is there literally a bullet list of talking points that you're allowed to say and can't deviate from? And what is the state trying to control in that conversation up front?
Well, it's my understanding when you read through the statute, you basically find a bullet point list, right? And if it's not on there, then there are accusations made against what I do and my intentions. And that is what essentially causes fear, not only in myself, but also in other counselors who don't want to be fined $5,000 time and also potentially unable to help any more kids at all as a licensed counselor. And so the whole nature of the conversation changes when you are afraid for your ability to continue helping kids at all.
Yeah, and how does this impact your other conversations that you're having as a counselor? Certainly, if they take your license away, you can't talk about anything. But has this really become the crux of your practice now because of how much the state is focusing on it?
Well, I think the way in which it changes the conversation is when you have one part of a conversation that is being suppressed and you can't talk about with openness and assertiveness, then it bleeds into other parts of your conversation. And so there are people coming in with all kinds of anxiety, depression, suicidality, all kinds of other issues. And this is one piece of the puzzle. And since I'm not willing to have half of a conversation due to this law, I'm just not willing to have the conversation at all. And so that means that I'm having to turn away adolescents right now who are asking for my help and wanting it. And I'm not the only one. Other counselors are also just saying, this is too hot. I don't want to touch it. So I'm going to refer out.
Wow. From this generational perspective, too, it's so interesting to me that Gen Z is very, very much struggling with the gender dysphoria component of this conversation. New studies are suggesting that upwards of 20% of our generation in some way, shape, or form is identifying as gender nonconforming or gender queer. That social contagion aspect, how do you see that continuing to impact the field of counseling, especially as more laws like this might pop up around the country?
You know, one thing I love about counseling is we all have these different perspectives. People are giving us advice and people are telling us what they think, and then we kind of infer what we should think too. And counseling is this beautiful, special relationship where we get time and space to sort out, I'm hearing this, I'm hearing that, I'm telling myself this, I'm doubting that. Let's sort. And that is the beauty of being able to have a full conversation that is not intruded upon by the rules of the state in this way.
And I just want to point out, I love how Kaley talks about what that counseling process is. And what's disturbing is that actually Colorado's placed a label on that to call that conversion therapy, to be able to sit and to listen and to talk and to sort out. And they're lumping it in the same bucket as coercive or aversive types of therapy that it's just not the same thing. Talking and listening to people is very different than the label that Colorado's putting on this. They're lumping it all into one bucket.
Which is so ironic because the only coercion I'm actually seeing is coercion against the professionals here and making you say only one scripted point of talking points there. As this continues to progress from a legal perspective, Kristen, are we expecting more laws like this to pop up around the country? What can we expect from the Supreme Court case today that you folks are arguing? And how can people continue to pay attention to this in their own backyard?
Well, I hope you won't see more loss because I hope that we win. And if we do win, I think that it could be very helpful to, again, reminding people that this is about individuals who are voluntarily seeking these conversations. They are setting their own goals, and they should be able to work with people to achieve those goals. So my hope is that you won't continue to see that because the Supreme Court will say this is unconstitutional to come into the counseling room and dictate these conversations one way. I think in terms of the gender identity or gender ideology, you'll continue to see cases play out. And even as we look in Scrimeti, which the public can read and should read, you will see where the science is playing out and how there's beginning to be overwhelming scientific evidence that there are really harmful consequences to pushing kids down this one-way conveyor.
Yeah. Kaley, in our last couple of minutes together, I would love to ask you about your faith, because in the last few weeks, with a lot of darkness and a lot of evil and violence that we're seeing in our country, we're also seeing this huge mounting courage to publicly embrace Christianity and to not apologize for the things that we believe in. That's a huge component of your case as a Christian counselor, and I know you'll be sharing a bit with the Supreme Court today about that. Can you walk us through what that means to you, and if you have a message of encouragement for other Christian counselors out there?
Well, of course, I am everywhere I go, and God defines my identity as made in his likeness and image, and he also tells me that everyone else is made in his likeness and image. And I think that is what inspires me to value the counseling process, is that we are incredibly valuable and we are worth investing in. God loves us in and through our struggles. We can meet him there. And so what better way to spend my time during the day?
Amen to that. Ladies, thank you both so much for joining us on the Isabel Brown Show. We are so excited to have people follow your case and your continued fight for freedom of expression where it really, really matters in serving people and helping people. And best of luck at the Supreme Court today. We know you're going to knock it out of the park.
Thanks so much.
Thank you very much.